This is an expedited dispositional review hearing in the matter of E.G. Jr. and S.C. Case numbers 22-51687-NA and 22-51884-NA. Present in the virtual courtroom, we have Mother Diamond Jones via telephone. We have attorney Jessica Lowry. We have Mr. Gregory's attorney Stephanie Cardenas. We have EC's Unknown Father's attorney Matt Berry. We have the children's attorney Melissa Calais and various agency workers. Ms. Calais.
All right, I thought that Laura was going to be running this hearing.
Okay.
I'm happy to if she would prefer,
right. But I can do that, Your Honor.
Okay.
I'd like to call Emily Nicholson.
Okay, would you raise your right hand? Would you state your full name for the record?
It's Emily Nicholson. First name Emily, last name is Nicholson.
Do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you.
Ms. Nicholson, when were the children returned to the mother?
They were returned on May 3rd, 2024.
Right. And what services were in the home at that time?
KRP was in place in the home with Ms. Jones and the children. And Ms. Jones was previously in counseling before in April.
Was she supposed to be in counseling when the children returned home?
Yes.
Okay. Did that counseling continue?
It did not, no.
And why is that?
Ms. Jones was unsuccessfully discharged due to a lack of progress being made and unwillingness to discuss her barriers.
Okay. While we're on that subject, I guess since May up to present date, has emotional stability been a concern for this case?
It has, yes.
Would you tell the court about that?
Ms. Jones has a history of domestic violence where her emotional state is where she gets frustrated, and there has been instances where Ms. Jones was at the school of EJ's school where she was intimidating and being disrespectful towards school staff to the point where she was asked to leave. Ms. Jones also struggles to work with others, which contributes to our concerns of her emotional stability.
All right. And kind of most recently, I think towards the end of October, you were trying to problem solve with her, I believe, about housing or food, and she had put a bucket over her head when you were talking to her. Is that correct?
Yes, that's correct.
Can you explain that to the court, what was happening there?
I was speaking with Ms. Jones about different housing resources, about Salvation Army or community rebuilders. Ms. Jones was working to pack the items in her home, and then she picked up the bucket and then went to go place it over her head. And then she stated that she needed to seem like she was listening to what I was telling her.
With the bucket over her head, she wanted to listen to you with the bucket on her head.
That's correct.
Okay. You said, I believe KRP was in the home. What goals were they working on?
Ms. Jones had the goal to demonstrate the ability to parent her children, which included to meet their basic needs, their emotional needs, and their educational needs, as well as being able to show that she can able to prepare for her future goals.
Right. And did KRP end successfully?
That's true. They unsuccessfully discharged.
Oh, unsuccessful.
Yes, it was unsuccessfully discharged in late July.
Okay. Due to lack of engagement, or what was the reason for the discharge?
Lack of engagement and lack of progress made towards the goals.
Okay. Let's talk about that. For meeting the basic needs, did she obtain employment?
She had employment in the past. She did not work from June on until present. I've had conversations with Ms. Jones to encourage her to search for employment and to obtain an income so that she could provide for her children. And she reported to me that she was looking for employment, but she never did gain employment.
Did she have a desire to be employed?
Not from my understanding, no.
All right. And did she indicate any barriers for herself to gain employment?
Ms. Jones, her children was in the home and they were not in school at that time. So childcare was a barrier. I had also worked with Ms. Jones to identify childcare. She did have childcare when the children were returned home. And then something happened and that childcare was no longer available. And I worked with Ms. Jones to identify other childcare. And that was never fully completed.
Did she have funding for childcare through DHS?
She was accepted for childcare, yes.
All right. So it was a matter of her finding places for her children for the childcare.
Yes, that's correct. She did find a place. However, the agency was going to pay for 1 week of that childcare for Ms. Jones. We asked Ms. Jones to give us a plan for after that 1 week, so we knew that there was childcare afterwards, and she was unable to find childcare after that 1 week.
You mean find childcare or pay for childcare?
Both.
Okay. How did she then meet the basic needs of her children then, the housing, the food, if she had no job?
Ms. Jones utilized her church community. She also utilized food banks. She had KRP transport her to food banks quite often. So she utilized KRP for food banks.
Did your agency or yourself have concern then about how she was going to sustain herself and her children over the long term?
We did, yes.
Did you have conversations with Ms. Jones about that?
We did. We had conversations with Ms. Jones of utilizing the community resources more, and Ms. Jones was not accepting the encouragement.
Right. What about housing? How is she paying for housing?
Ms. Jones had a housing voucher that was up in October. Ms. Jones and I, the agency, we discussed housing resources. Ms. Jones did have she had an option to move into her friend's home with the friend's other young children. Ms. Jones reported to me that that was going to be her plan, and then she reported to me that that was no longer available. And then Ms. Jones reported to me that she was going to stay in a hotel for 2 weeks. And then after that, she wanted to go to a shelter with her kids. I explained to Ms. Jones that because the kids are returned home, that we can't allow them to be in the housing shelter. And then there was an option of Ms. Jones going to Saginaw, but she was not fully committed to that.
All right. And in terms of the housing voucher, I mean, was it her, meaning Ms. Jones' own doing by not getting a job in order to pay for housing? Could she have continued in this home had she had employment?
I believe the lease was up on the 18th, and therefore the landlord wanted her out on the 18th.
All right. And had you been talking with her all summer about, what's the plan for housing when your voucher runs out?
I did, yes.
Right. And did she ever have a solid plan other than this, that, and the other thing that never panned out?
She did not know.
Okay. I think also in your petition, you had concern about you were never able to see the kids privately. Is that correct?
I was able to see the children privately at some of the visits, but it wasn't consistently.
Okay. And did you receive CPS reports over the course of the last couple of months about her behavior with the children?
I did, yes.
Sorry, I'm going to interrupt a moment just to note on the record that Ms. Jones has left the hearing.
Thank you.
Go ahead. I'm sorry.
That's right. Did you receive CPS reports about her parenting her children? Concerns about that?
I did, yes.
All right. And is that what you were trying to interview the children about?
Yes, that's correct.
Were you able to do that fully?
No, Miss Jones came into the room when I was speaking with SC.
Okay. Also, it appears that criminality became a problem over the last couple of months. What can you tell the court about that?
Miss Jones was in a vehicle with her children and an unidentified individual who was driving the car. They ended up being pulled over. Miss Jones originally was in the front passenger seat of the car, and then she moved to the back of the vehicle near her children. And when the police went to talk to Miss Jones, she gave a fake name and then struggled to get out of the car. And then she resisted arrest.
And then she was arrested and the children had to go somewhere else.
Yes, that's correct.
Does she have outstanding criminal charges at other places?
She did. She did. Yes.
And do you remember what those were?
I believe one of them was drinking in public. The other was, I believe they were domestic charges.
Okay. And as the time of the removal anyway, those charges were still outstanding. Like she still needed to take care of those.
Yes, that's correct.
All right. And after the children, or after she was arrested, then you executed a pickup order for the children. Is that right?
Yes, that's correct.
And what are your recommendations today?
It is respectfully recommended that EG and SC remain temporary court wards and remain in their out-of-home placement with their current relative caregiver. It is respectfully recommended that Ms. Diamond Jones and Mr. Eddie Gregory's parent times be supervised or unsupervised at the agency's discretion. It is respectfully recommended that Ms. Diamond Jones and Mr. Eddie Gregory participate and benefit from their parent agency treatment plan, and that this matter be reviewed in 90 days.
Okay. All right. Thank you. I don't have any further questions.
Ms. Calais.
Thank you. Ms. Nicholson, in preparation for today's hearing, did you prepare a court addendum dated October 30th, 2024?
I did, yes.
I would like to offer that court addendum as Exhibit 1.
Any objection?
No, Your Honor.
All right, it's admitted.
Right, thank you. And just to further clarify on your testimony, the incident regarding the arrest, were Ms. Jones' children there and present when she was arrested?
Yes, that's correct.
Okay. And prior to her arrest, were you aware that she had these outstanding warrants?
I did not know.
Okay, so she never informed the agency or asked for any assistance in trying to pay court fees or otherwise get these resolved. Is that right?
That's correct.
Okay. And you said that there was a plan to possibly move to Saginaw. Was that specifically with the home of the paternal grandmother who previously had placement of the children?
Yes, that's correct.
Okay. And what was your understanding of that plan?
My understanding was that Miss Jones and the children were going to move into the home. Miss Jones reported that she wanted to go to school or work while she was there. Miss Tina didn't require Miss Jones to pay any rent, but that she just contribute to the household in some way.
And Ms. Tina, you're referring to Ms. Tina Lindsay Watley, the paternal grandmother of EG and the fictive kin of SC who previously had placement?
Yes, that's correct.
And she presently has physical placement of the children, is that right?
Yes, that's correct.
Okay. Is she still willing to allow Ms. Jones to be present or to live in her home?
I believe that's still true.
Okay. And did you have an opportunity to visit the children in the home where they are currently placed?
I have, yes.
Okay. And do you believe that home is appropriate for them at this time?
It is, yes.
Okay. Thank you. No further questions.
Thank you, Ms. Lowry.
Thank you. When we were reviewing this case, I think it was maybe September 12th. At that point, the same facts were true. Miss Jones had been unsuccessfully discharged from KRP. Is that correct?
Just a second. I'm going to interrupt again to indicate Ms. Jones has rejoined the Zoom.
Great. Thank you.
Sorry, Ms. Lowry. Go ahead.
You. So those facts were true at that time when we reviewed the case in September.
Yes, that's correct.
Okay. And at that point, you were requesting removal of the children and you did not have concerns about the children's care?
At that point, that's correct.
All right. As far as the child care, so in October, Miss Jones's lease was up. Miss Jones was debating different placement or living situations at that point. She had secured childcare. Is that correct? She had been to a place, picked a place. Is that correct?
She had childcare for 1 week, but after that 1 week, it was unclear of what her plans were.
I'm sorry. I saw Ms. Cardenas raised her hand. No, she's shaking her head. Okay, that was a mistake. Sorry, go ahead. I'm sorry, Ms. Nicholson. I keep interrupting you.
Okay, but I thought you said that she was going to receive DHS payments for childcare. So when you say she had it for 1 week, what does that mean? Like she would only be able to have childcare for 1 week because of payment or because of availability?
The 1 week was from the agency to pay for the 1 week of childcare for Miss Jones. And then after that 1 week, there was no clear plan for childcare.
Okay. Did you not testify that she would be able to receive DHS payments for childcare?
That's correct. That is correct. However, she did not identify further childcare like as a placement or an individual to provide the childcare.
Okay, so that was still a possibility, but at this point, she's not sure if she's. Oops. No, sorry, I don't know. Okay, but at this point, she's trying to determine if she's going to live in Saginaw, if she's going to find a home or a place to stay here. Is that correct?
That's correct.
All right, so there were a lot of things up in the air as far as securing employment, deciding on a child care at that time period. Would you agree?
Yes, that's correct.
And Miss Jones has been employed on and off throughout the case. She is able to get employment. She worked at Dollar General for quite a long time. She's had different jobs. Would you agree?
She did, yes.
All right. So when Miss Jones came to you to discuss her options following the lease coming up, she mentioned going to a shelter with her children. And why did the agency say that was not appropriate or not allowed?
Because while the children are still in care, we cannot have them homeless in a shelter.
Okay, but these are homeless shelters for mothers and children, correct?
That's correct. But because the case is still open, we couldn't allow the children to be homeless in the shelter.
All right. And one of the reasons she was looking at that was so that the kids can continue in their schools that they're currently placed in right now. Is that your understanding?
Yes, that's correct.
Okay. And so the agency said, you can't do that. So then she said, all right, I can move to Saginaw with paternal grandmother. Is that correct?
She did at one point say that, but then she continued to go back and forth because she wanted to stay in Grand Rapids, and then she never fully committed to moving to Saginaw.
Did she tell you that she was going to move there in 2 weeks because she had a hotel paid for 2 weeks, correct?
She did have a hotel for 2 weeks.
Okay. And was she going to move to Saginaw after the 2 weeks were up?
She said that she was thinking about that, but she did not make a actual decision.
All right. And unfortunately, that was not able to occur due to her incarceration.
That's correct.
All right. So, but as of today, Miss Tina would allow her to go live in her home with her children if there was not a removal order in place?
That's correct.
And that would be appropriate housing?
It would be.
Are the children bonded to their mother?
They are.
And is she appropriate in her parenting of the children, loving, affectionate?
Miss Jones does have appropriate parenting skills.
Okay. That has never been a concern in this case.
Miss Jones does have
Her ability to parent the children, to be with the children, keep them, those types of things.
Our concerns were that Miss Jones does struggle to meet their basic needs, but Miss Jones' parenting skills were appropriate.
Okay. But you've been overseeing the case for quite a long time. Miss Jones has food stamps over $570 or so a month. Is that correct?
That's correct.
You've been in the home. There's food. The children appear healthy.
That's correct.
And they attend school every single day. So the school has had eyes on the children as well.
SC did start school in October and EG did start late August. Okay.
Has the school ever reached out to you with any concerns for the children or their care?
They have not.
And just to clarify, some of the outstanding charges, those are charges the court and everybody has been aware of since we've been going out through this case. These are not new charges outside of the most recent arrest, but the warrants that she was picked up for, those were just fines. She had dealt with them in court. There were outstanding things that were owed on those cases. Is that your understanding?
That's my understanding, but I was not aware that she had those fines.
Okay, but you knew that she had the charges for those or the convictions for those offenses.
For the domestic violence, yes.
Okay. And finances are an issue. Fines are probably the last thing on her list that she's going to be taking care of when she's trying to do what she can for her kids. Would you agree?
Yes, that's correct.
All right. So at this point, her kids are in Saginaw. She has the ability to go live with her kids and the paternal grandmother. There would be a approved caregiver in the home if she was allowed to live there and the children were not removed from her care. Is that accurate?
That would be correct.
All right. What is the risk of harm to the children right now if they were placed back in Miss Jones's care, living in Miss Tina Watley's home?
The risk would be Miss Jones has a history of domestic violence, so it's unclear if Miss Jones would be able to live appropriately with Miss Tina Lindsay Watley. Miss Jones also.
But you had approved that plan when she addressed that plan with you prior to her arrest. Is that correct?
Yes, that's correct.
And the domestic violence involved a situation with her sister at the very beginning of this case. Is that correct?
That's correct.
And then I think maybe with Mr. Gregory, who's incarcerated.
That's correct.
Okay. Sorry, continue on. What is the risk of harm to the children?
Ms. Jones' emotional stability is a concern due to the additional trauma that the kids have now faced from Ms. Jones' arrest and the removal. The agency would like to see Ms. Jones engage in therapy services so that she can reduce that barrier.
And this was something that was requested back in September after the last review hearing. And was Ms. Jones provided with any counseling referrals?
I did have a conversation with Ms. Jones about putting in referrals. Ms. Jones reported to me that she did not want me to put in the referrals, that she wanted to find her own counselor. And I asked that she did look for her counselor, and she has not provided me any information.
Okay. And Ms. Jones was not sure if she'd be living in Kent County or in Saginaw and Bay County at that time, or at least for the last probably month or so.
That's correct.
Okay. All right. I don't have any other questions, Your Honor.
Thank you. Ms. Cardenas.
Thank you. Your Honor, I have no questions.
All right. Mr. Berry.
No questions, Your Honor.
Ms. Clifton.
No follow-up, Your Honor.
Ms. Colley.
No follow-up. Thank you.
All right. Any additional witnesses, Ms. Clifton?
No, Your Honor.
Ms. Colley.
No, Your Honor.
Ms. Lowry.
No, Your Honor.
Ms. Cardenas.
No, Your Honor.
Mr. Berry.
No, Your Honor.
All right. Statements. Ms. Clifton.
Your Honor, I would ask that you uphold the removal. I think this case, the last time you reviewed it, was hanging by a thread even then. But for the mother's unwillingness to look for a job, she was not able to sustain herself or her children in terms of getting housing, being able to feed her children. I think we have new concerns, or continued, I should say, concerns, because DV was an issue initially about her emotional stability, as CPS had gotten a few school had called indicating Miss Jones was acting inappropriately at school, and then her unwillingness to firm up a plan once it did become in crisis. So for those reasons, I would ask you to uphold the removal.
Thank you, Ms. Colley.
Thank you, Your Honor. I would also ask the court to uphold the removal. I did have an opportunity to meet with the children via Zoom following the removal after they were placed with paternal grandmother. They seem to be doing quite well in paternal grandmother's care. I was pleased to see that Eddie Jr. seemed more at ease than he had when I had visited him in the mother's home as this case has been pending. I would agree with Ms. Clifton that there were certainly causes for concerns prior to the removal. However, given that Ms. Jones was parenting the children appropriately, I didn't previously think that removal was warranted. However, with the loss of housing, the inability of Ms. Jones to make and stick with a plan until, again, as Ms. Clifton indicated, it really became an emergency situation. And then the arrest of mother, I do believe that now it is appropriate to remove the children. I don't think that they could simply stay at Ms. Tina Lindsay Watley's home without having a court order of placement, because we already ran into these issues in the case previously where Ms. Jones would get upset, threaten to remove the children if she wasn't getting her way. And that's what led to the previous removal order in this case. And I don't think it would be good to set up that same dynamic again, particularly when Ms. Jones has not taken any steps really to address the barriers in this case, particularly that emotional stability barrier. So I would ask the court to uphold the removal order. And I'm especially concerned about the arrest being in front of the children. Ms. Jones certainly could have asked the agency for assistance if she was simply unable to come up with funds for the fines, or she could have looked more seriously into work to avoid this issue. But there was clear harm to the children that came from witnessing their mother's arrest, or resisting arrest, providing fake information to a police officer. So I do believe that now there is clear evidence of mother's actions resulting in harm to the children, and I believe that removal is appropriate. Thank you.
Thank you. Ms. Lowry?
Thank you, Your Honor. On behalf of Ms. Jones, we obviously do not agree with removal. Ms. Jones has been released from jail. The arrest was a surprise arrest. She was with somebody who didn't have a plate on their car, I believe is what occurred. There were outstanding fines that are due. Unfortunately, that situation occurred. Obviously, it's been a pretty stressful last month for Ms. Jones, but she's been doing her best. Her kids are at school every day, and no concerns with their care. They're very bonded to their mother. They love their mother. She loves them very much. And unfortunately, this is a difficult situation where Ms. Jones is trying to decide what the plan is. She wanted to take the children to a shelter so that they could still stay at the school that they're at and give them some stability, continue with that. And the agency said that she could not do that, which I think is just really kind of sad while she's trying to sort through some of this stuff. And so the alternate plan was to go to Saginaw. She had 2 weeks in a hotel, was hoping to get the kids through school, 2 weeks paid in a hotel, and then, look at schools in Saginaw for them and to go to paternal grandmother's home. I believe that's still an option. She's still willing to go there so that she can be with her children. I don't think there's any concerns about her ability to parent the children appropriately. And my recollection is that we were actually getting closer to closing this case than, being on hanging by a thread. And so there are financial stressors, but I know Ms. Jones was kind of trying to figure out, okay, do I get a job here or are we moving to Saginaw? And unfortunately, when you don't have a lot of financial resources, it's not very easy to just make decisions like, oh, I'll go live here. I'll go get an apartment here. So I think the court should take those things into consideration. And I don't believe there's a substantial risk of harm to the children. I think there's a lot of circumstances, but Ms. Jones was utilizing resources. She was utilizing a church. She had food stamps. Her children were cared for. Their needs were being met. And unfortunately, housing's a big one and a difficult one to address. Thank you.
Thank you. Ms. Cardenas?
Thank you. Your client, Your Honor, my client is aware of the situation. However, at this time, we'd like to make no statement. Thank you.
All right. Mr. Berry?
No statement, Your Honor.
All right. Thank you. The court finds that the lawyer guardian ad litem has complied with the requirements of the statute, that returning these children to a parent at this time would cause a substantial risk of harm to the children's life, physical health, and mental well-being. This most recent incident that caused the removal of the children just underscores Ms. Jones's significant need for treatment of her emotional instability, which has been an issue throughout this case. And she's always put it off. She's always wanted to get her own counselor. There's always been some excuse, but frankly, she simply has not done what she needs to do. And this most recent incident, which did occur in front of the children and caused them harm, is evidence that she's not able to parent at this time appropriately. I know she loves the children. That's never been an issue. But her emotional instability and her that causes the poor judgment that she exercises, and the conflicts that she gets into with other people, both in front of the children and outside of their presence, really is a concern for the court. That the needs of these children can be met in a foster family home. The court orders that the children continue in the protective and temporary custody court, that they're placed with the Department for Care and Supervision, that the adjudicated respondents comply with and benefit from the case service plan, that parenting time of Ms. Jones is at the discretion of the department to allow unsupervised or supervised parenting time by its designee. Parenting time of Mr. Gregory is to be supervised until further order of the court. Continue the attorneys in this matter. And our next hearing will be on December 3rd, which we had previously set as a review hearing. However, we will also notice that out for an adjudication on the new petition. Is there anything further that we need to address at this time?
No, Your Honor, not for me.
No, Your Honor.
No, Your Honor.
No, Your Honor.
All right, thank you. We're adjourned.